I'm Kelly Garver with Sterk Family Law Group. I'm the Business Development and Marketing Manager, and I work with our team of attorneys and staff. This afternoon, our attorneys Gwendolyn J, Sterk and Amy Schellekens will be coming out. I know that to talk to you a little bit about some guardianship questions and other legal questions which you may have. I know that we had received some questions from your end which we'll be prepared to answer, and then also we'll be open to other questions as well. Within your packet, these are all for you to take away. Please, feel free to write on them, and then add any questions, just raise your hand. But at this time, I'll go ahead and let Amy and Gwen get started.
Welcome everybody. It's such an honor to be here at Cornerstone. We got an introduction to your organization in the last couple of years, and we've been able to do a lot of videotaping as well as some other information relative to the practice and the work that we do and that you do. And I have to tell you that it is an honor for us to be with you, because your work every day makes a difference. And sometimes in the mundane indulgence of life, we all don't feel like getting up and going to work every day. Is that a fair statement? But as a result of this, what I would tell each and every one of you is that you need to know that from our perspective, you render such an incredible service to our community, and you are the essence of what makes our holistic approach work. So at Sterk Family Law, we believe in a holistic approach to family law. And what that means is we don't just look at the legal piece, because we believe that we are one portion of the global portion of helping somebody move forward with their lives. As you well know, if a disabled person gets a guardianship, that legal guardianship isn't the be end and all end of what that needs to be handled. As a matter of fact, it's only a minuscule portion. What you do to service the individuals, to allow them and help them go through and forward with their lives, is what's most important. So we understand that, and so globally we try to reach out to people who assist with our clientele, perhaps wards. We do divorce, we do estate planning, we do post-decree, we do paternity work, and this is our work. So what we're trying to do is put together a network, and for the past 30 years of my career in family law is we believe in this holistic approach. So meeting all of you is our great honor today. That's what I want to say first and foremost. Well, in preparing for guardianship, and I know that you all had some very specific questions, and I am sure that all of you are somewhat familiar with the basic operation of guardianships, at the same time going through and making sure that we understand all the types, the process, getting a refresher and all that is, in my opinion, crucial, because in preparing for this, it was very nice for myself to do a refresher, and we have all of the material outlined in a series of articles that's contained in your package. In your package, we try to give you things that I think are going to be important for you to understand the whole picture. On one side of your package, you're going to see all of the court forms that are utilized in Will County for guardianship of the person in a state for an adult disabled guardian. You're also going to see the process for guardianship of a minor, and you're also going to see the court forms for emergency guardianships. What's not included in there, because there's not necessarily a set form, is if you are looking to terminate a guardianship, and we will talk about that during the course of the presentation. So that's one half of the material. On the other side of the package, you will see material with regard to various blog articles that over the next several months will be posted onto our website, as well as material that we are putting together to be able to illustrate and give answers in more detail to some of the essential questions of guardianship. In addition to that, inserted in your package is something I just recently created, which is this financial summary of the ward's estate. I'm sure all of you know that sometimes when someone gets appointed as guardian, it's a little overwhelming to find out how to put together that financial package. So we've recently created that form as well. So that kind of gives you an introduction. There's also flyers in the material about what it is that our firm does. And in addition to that, we have a flyer for our Building Hope for the Future program, which is a free program we provide to the community, which Kelly Garver will tell you about at the end of our presentation. So let's get started. Who needs a guardianship, and who can be a guardian? That's really the first question that everybody has to ask when you're dealing with this question. So we know that a legal guardian is a person who has legal authority to care for the personal and or property interest of a ward. You all know that the ward is the person over whom the guardianship has been appointed. I'm sure you know that word. But the issue is that you don't have to be both. You can be one or the other. So you could be guardian of the person, you could be guardian of the estate, or you could be a combination of both. Now, who needs a guardianship in the state of Illinois? And the answer is an individual who is unable to manage his or her own affairs. Now that's a very broad stroke, and the issue in family law and in the guardianship practices is that that can mean various things, and it can be up to a judge. Now I've been practicing for 30 years, so I'm going to tell all of you that depending on what county you're going into, and we practice in DuPage, Cook, and Will counties, and depending on what particular judge you might go before, they might have a different perception on who it is that needs a guardian. So I want to say that first and foremost, it's a very broad stroke categories, and it can be then up to the discretion of the court as to whether or not they feel it's necessary or not. In other words, there's not an absolute clear-cut, bright line that tells us when you need a guardianship or not. There are 4 categories of individuals who may need a guardianship, and they include individuals who've had mental deterioration to a certain capacity that they're not able to make decisions, a physical incapacity, mental illness, which is different under the statute, very interestingly, than mental deterioration, because you don't have to prove that there is a mental illness, or they have a developmental disability. So again, when you really look at it, and all of you as professionals know, those are very broad terms, and they are subject to a broad range of interpretation. And the answer is you're not wrong about that, and sometimes it depends on how you approach it to a judge and who the judge is that ultimately makes the decision. So, a guardian can also be appointed, and this is very interesting, and over the course of my career I have seen this more and more, is if somebody is engaging in gambling, idleness, debauchery, or excessive use of intoxicants or drugs. Isn't that interesting? So that's another category when they are spending or they're wasting their own estate so that they are wanting or suffering. And so that really is an even broader category, because you've got the first categories where somebody might not fit in that nice box, right? But then you can go with those broader definitions. So that's who can need a guardian. But just because you or I feel that somebody needs a guardianship doesn't mean that the law is going to appoint them as a guardian and then name them as a ward of the estate. So the next question becomes, who can be a guardian in Illinois? Here's the real 5 requirements. You have to be 18 years of age. You have to be a resident of the United States. That's pretty broad. You have to be a person of sound mind. I'm not sure what that means. I've been practicing law for 30 years, but I would say that not everybody's of sound mind, but whatever. And here's a good one that's pretty firm. You're not adjudicated a disabled person yourself. So you can't be adjudicated that you need a guardian and then you want to be a guardian for somebody else. That's prohibited. And the last one is you can't be convicted of a felony, but then there's a catch-all provision. If the felony is one that would not cause a harm or threat to a minor or a elderly or a person with a disability, you could overcome that burden if you've shown that you've appropriately rehabbed, you have shown evidence that you're able to care for the ward. So it's not a lockdown. A lot of people have that misperception that if you're convicted of a felony, you're out, you can't be a guardian. That is not the law in Illinois, and it's really a case-by-case basis with who the individual judge may be. Now, we start with that provision, but what if you have an adult disabled? So, in your situation, you might see somebody come in as an older adult who needs services now for the first time. When that older adult would have been of sound mind and able to make decisions, that adult could have done what we call a power of attorney in lieu of guardianship. So a power of attorney is something that you do in your estate plan. If you're going to have an estate plan, generally you're going to create a will, and in your will you're going to name who you prefer to be your guardians, and if they're unable to act, in our estate planning department we're going to put successor guardians in that will ourselves. And then alternatively you can have an attorney, a power of attorney. Now what's interesting is that a power of attorney can be what's called springing or non-springing. A non-springing power of attorney would be one that's effective immediately, meaning that I've decided that I'm 55 years old, I no longer want to take care of my affairs, I'm going to transfer them to somebody else, and you take care of my business. That is not the norm. The norm is that most people create what we call a springing power of attorney that says that if I'm unable to act, or if I become disabled and unable to act, then that person I name becomes power of attorney to make decisions for me. Now those power of attorneys in Illinois are basically in 2 structures. One is a power of attorney for property, and the other one is a power of attorney for healthcare decision making. So those are the two forms of power of attorneys. You know, I struggle with this question because I've had this in the 30 years I've been practicing, where someone comes in and says, well, you know, Dad did give us power of attorney to make decisions, and Dad thinks he's really of sound mind, but us kids know better, and we know that Dad is really suffering from dementia or Alzheimer's in the beginning of it, and it becomes a controversy because Dad is sitting there saying, I want to make my own decisions. In those cases, sometimes the doctors will accept the power of attorneys, and in some cases, even though Dad elected you as power of attorney, you still have to go into court and make sure that they're adjudicated disabled before that comes into play. So just because you have a springing power of attorney, you know, there still becomes that threshold question. And I remember a very cute case that I had years and years ago, probably 20 years ago, and it was where Grandpa, he really thought that he could live on his own, but he kept making hot dogs. And every time he'd make a hot dog in his condo, he would leave the burner on, and the hot dog would burn away, and then the fire, you know, alarm would go off, and the fire department would be there. And the first couple times the fire department said, don't worry about it, it happens. But then when we got to the fourth and the fifth time, Dad still struggled with that, and to the day that the guardianship was appointed by the judge, still went into court and said, you know, I can make my own decisions. I'm still really of good health and of good mind. So these are struggles for people, but that's just what happens. Is in that case, the family really didn't want to get into a litigation because Dad had appointed his son as guardian, but these things happen. So you have to remember, when dealing with guardianships and when you're dealing with power of attorneys, that there still may be litigation that needs to occur because someone else won't recognize that. The last category of guardianships is, we all know about that, as guardian of a minor. And a guardian of a minor isn't necessary if we have a parent who is able and willing to act. So remember that the parent really is the legal guardian of a child until what age, guys? 18, that's correct. Very interesting, because Amy and I have this conversation a lot. So Amy, tell them, if you're going to get divorced, how long do you have to pay child support till?
Till 19, unless they've already graduated high school at age 18.
That's correct. However, for guardianship law, the real powers over the child end at the age of 18. So this is a good example, and I want to make sure that we are all talking about it, is just because there's two different areas of law in Illinois, big red flag waving, sometimes the law contradicts itself. So here in guardianship we have 18, and yet in child support we say emancipation doesn't occur until 19 or when they graduate from high school, whichever occurs later. Do you see what I'm saying? So that's, or whatever occurs first, sorry. And so that becomes some of the areas of contradiction as well. But as a general rule of thumb for guardianship and under the estate planning section and the probate act, the age is 18 for that purpose. So that really talks about who needs a guardianship and who can be a guardian in Illinois. So that gets us to the next question. Fine, we know that we need a guardian, or we think we need a guardianship, and we are going to file a petition for it, and we'll talk about that in a minute. But what are the various types of guardianship that you can have in Illinois? Because it's important to know this. And I think that the most underused provision in the Probate Act about guardianships is what we call limited guardians. How many of you experience limited guardians? Very few. And all of you work with wards, right? Very interesting. But a limited guardianship is an option when a disabled person is able to make some of the disabled's financial or personal decisions, but at that point in time they can't make all of them. So what the court will do is they will specify what decisions the ward should be able to make for himself or herself, and what decisions should be made by the actual guardian. And what's interesting is, and it was one of the questions that we're going to go over in the second half of the presentation, about what is the use of limited guardians and maybe why don't we have more limited guardians in Illinois. And I, always thought it was really the court, and we have a judge in DuPage, right?
He loves them.
He loves limited guardians. So it's interesting. And then we have judges elsewhere who just don't do them. But what was fascinating is that this article talked about the fact that our physicians don't know about the option of limited guardians. And that was a very key explanation to me, because the physicians get the report. The physicians are going on the line, so to speak, to say, I think this person is incapacitated, that they can't make their decisions, and the physicians don't want to put in the report, well, I think that the potential ward could make A, B, and C decision, but they can't make D, E, and F. So one of the arguments that is out there is that the physicians need to be educated about guardianships to be able to create the reports in a better way, because as you all know, limited guardians would be a better way for a lot of individuals. It would give them freedom, and yet it wouldn't give them ultimate decision over larger decisions. But that's not our norm in terms of general operations. But I'm going to talk about that in a minute in terms of what the ward might be able to do to fight back for a limited guardianship. But in general, the other type of guardian we have is what's called a plenary guardianship. And in that particular situation, it's really a total guardianship when the person with disability is considered incapacitated and the proposed ward can't make their decisions on themselves. And what's interesting is that the plenary guardianship really gives them power over all decisions. Now, it depends if they're a guardian of the person or a guardian of the estate, which we'll get to in a minute, but yet plenary refers to all decisions. The third type of guardianship is one that I think we see on the rise, especially recently. And if you think about those situations where guardianships might be needed in the case of intoxicants or drugs or gambling or something of that nature, or a situation arises where nobody took care of their business, you get into that emergency guardianship. And we gave you the forms for how that can be applied for, because under the Illinois Probate Act, a judge can appoint a temporary guardian to make the decision making if the immediate welfare and protection of the alleged person with the disabilities is critical to be made at that time. But under Illinois law, a temporary guardianship is only valid for 60 days. But sometimes what a judge will do is they will appoint a temporary guardian while the court-appointed guardian ad litem, and we're going to talk about that in a minute, is doing his or her investigation to move forward. So that's an emergency guardian. Categories underneath that, we're talking about guardianship of the person versus guardianship of the estate. We know that a guardianship of the person deals with their care, their comfort, health, education, and anything related to non-financial aspects of the person. Now, I have to tell you that I struggle with that one, because to me, every decision that you potentially make has an economic consequence. So I understand that sometimes we have two people and we have one making the decision for perhaps what programs they're going to be involved in, and then the guardian of the estate saying, well, there's not enough money to be able to facilitate it. But that really is the distinction there. But the guardian in that particular case, and I think it's an important word for all of you to know, is the word substituted judgment. Are you familiar with that concept? Substituted judgment means that when you are appointed as guardian of the person, you are not to do what you believe is in the best interest of the ward. This is critical, and I'm going to do a whole section in my presentation on it. You are to do what you believe the ward would have done had the ward been able to make the decision himself or herself. It is an area of the law that is not covered substantially, but it is clear in our statutory provisions that it is the theory of substituted judgment and not of best interests. Now, if you can't determine what the substituted judgment may be because the ward was never capable of making or articulating his or her preferences, we'll talk about that in a little bit, then maybe you have to use best interest standard, but it is critical that there be an understanding of that as well. The guardian of the estate, on the other hand, is the person who can manage the ward's property and finances. And the guardian of the estate has a legal obligation to report to the court and to account for all of the expenditures that they make. So in your packet, you'll see an initial financial summary of the ward's estate. And this is something that we have recently created, because what we find out is that a guardian of the estate gets appointed and they really don't know what type of assets. So if any of you are familiar with the Illinois family law statute, we now have what's called a financial affidavit that people have to prepare when they're going to do a family law matter, and people are stunned, for lack of a better word, when they really have to put down what are all of their category of assets, what are all of their expenses. So we've created this form in a substantially similar framework to be able to say these are the things that you have to start considering. And the guardian of the estate is accountable. They are a fiduciary that replaces the ward's conduct, meaning that they have an obligation legally and they can be required to post a bond. And in addition to posting the bond, they also might have personal liability if they misappropriate the standards. And I don't know if any of you saw that this week. It came out in the news that in one of the nursing homes, it wasn't in this area, but there is a facility in this area with the same name, and the person had survived World War II and had been in a concentration camp, but yet had $700,000 of assets misappropriated while being in a home, and then the home tried to cover it up. So talk about personal liability. There can be some real sanctions and some real liability there. So it is something to take very seriously within that structure. The next type of a guardian is what we call a guardian of a minor. This is where a parent of a child under the age of 18 is not capable of making decisions for purposes of the child. So for example, they live with a grandparent or they live with an aunt or uncle, and then a guardian is appointed to be able to take care of the child because the parent is unwilling, unable, or there is another circumstance. And you can also have a standby guardianship for up to 60 days. Amy, tell everybody about that limited guardianship of a minor. You can appoint it by filling out a form, right? It's kind of crazy for up to a year.
For up to a year you can.
Yeah.
It's obviously a very difficult process. The Constitution provides that parents are automatically going to have their say as long as it's safe for the children. So it's a difficult process.
It's a difficult process, but that interesting form, and that's only an exception under guardianship of minors, but I like to make a point by asking Amy that question because how interesting that a parent could give up and really transfer to another person their rights for up to a year without going to court. But guess what? All of our school districts got pretty smart because what was happening is that a parent was just signing that form, sending their child then in a school district that might have been more favorable than where they live, and so then the school district started arguing back, no, if we're going to now put out our money in our district for that particular student, you're going to have to do a formalized document. But it is available. So for example, if mom and dad are traveling to Europe and they're going to be gone, something of that
Military
case.
often use that as well.
That's correct. So that's guardianships of minors. Then there are the next types of guardians, which are called successor guardians or standby guardians. Now obviously if you're appointed a guardian of a person or of an estate, you might not be able to be there all the time and you might go in for surgery yourself, right? So for a period of time you can have a court order where a standby guardian might fill in for you for a period of 60 days or some short period of time because you don't have the ability to make that decisions during that time period. On the flip side of it, there are those instances where we find that successor guardians are important. Why are they important? Because the guardian that was appointed is no longer willing or able to act. Maybe they have now gotten into one of the areas where they're no longer qualified to make the decisions on behalf of the ward. And so that would be the successor guardian. What's critical is for all of you to know is in your estate plan, you can name your guardian and then you can name your successor guardian in the order in which you would like to have them appointed. The court will give certainly a great deal of deference to who the ward wanted to be appointed, but they are not completely bound by that because it might not be an appropriate person to do that guardianship in that instance. And so that really ties into the last one, which is what we call that testamentary guardian, and that's what we really call it, where you designated in advance who you would want to have named as your guardian. So that testamentary guardian, that's what we refer to it, but you still go into court and decide if you're going to be guardian of the person, guardian of the estate, unless there's some other way to do it with a power of attorney. So that's really the types of guardianship in Illinois. Kind of amazing, isn't it? Because you really don't think that there are that many alternatives for guardianship within the scope of Illinois. So the next question becomes, all right, now we know the types of guardians we want to be. What do we do if we want to become the guardian of a person? And I'm going to give you a very interesting tactic that we use in divorce. Somebody comes in and you know that a guardian now can pursue a divorce on behalf of a ward in certain circumstances and with leave of court. That's recent law in the last 5 years. So just because you have a guardian, if you're married, the guardian could then file an action on your behalf. And in addition, this other spouse could file for a divorce against you. And so we're going to have some material coming out in more detail about this. But what we've seen on the rise, and Amy, I think you would agree with this, is a number of individuals where a spouse files on behalf of their spouse to have a guardian appointed. So they filed for divorce, then they filed for guardianship of their spouse, but not for them to be appointed as guardian, but for somebody else to take over. So think about it from a different perspective. You've lived together for 40 years, you're married, you see that your spouse is suffering from dementia or some type of debilitating condition, your marriage cannot continue, let's just be frank, from a financial perspective, staying married may not be in the best interest of the family, so you want to get a divorce from your disabled spouse. In that instance, you could file a petition for the court to appoint a guardian. That guardian would be somebody different who then substitutes in for that person, and we do divorces from that perspective.
Right, it can't be your spouse. You can't
Right.
be the divorcing spouse and the guardian.
Right, you have to name somebody else. And that makes sense, right? Because you want to make sure that you're looking out for the best interest. So that's another instance where guardianships are being appointed. But if you want to be a guardian, you would then, and people come into our office all the time and say, I have a loved one who is disabled, I want to be appointed guardian. What are the steps to be able to do that? The first step is really getting a report of the physician, right? And so the report of the physician is then going to fill out, it's basically, and we give you a copy of the form. It has to be within the last 90 days. It's going to be a description of what the disability is. It's going to be an analysis of the evaluations that were conducted to draw the conclusion. It's going to be an opinion from the doctor as to whether or not the guardian is needed. It's going to be a recommendation about if there's another living situation that that particular proposed ward should be in, and it's going to be the signature of the doctor who did it. Now, I have to tell you, Amy, and see if you agree. I have a problem because I'm saying to people, go violate this guy's HIPAA's rights and go get a form from their recent doctor to get a report of the physician. I struggle with that to this day.
That's right.
And I also struggle, that's a problem. And I struggle, number two, with somebody that has an intellectual or a mental health condition that leads them to need a guardianship appointed in the potential ward's mental health rights under the mental health code. Because we violate, let's just all be clear, we violate the mental health code when we file these report of physicians in a public record.
Yes.
It makes me cringe, but nevertheless, that's just what the law has provided. But what's important for all of you to know is if you cannot get a report of the physician as the proposed guardian, you're not out of the water. You can file a petition with the court stating why the guardianship is necessary and ask the court to enter an order that, one, the proposed ward go through an evaluation, two, that the proposed ward's medical records be ordered to be delivered to the court, or three, that any existing physician complete an analysis for purposes of the court. So you're not dead in the water. That was an old notion that you had to get a statement of the physician or a report of the physician, and you had to have that. Now, is that the preferred way? Yes. But to have a report of the physician coming in, it makes the whole process a little cleaner. But I have to tell you, if I was a physician, which I'm not, I would never sign one of those without a court order.
Especially when the divorce ones come in.
Sure.
They don't want to go to the doctor. They know what's going on.
And it was interesting because we recently had a situation where our client had power of attorney for health care, and the physician said, I'm still not going to give it to you because I think it violates this individual's rights. So you then have to go into court to get that step. And that's something that's relatively newer on the rise in what we see in our guardianship cases. So something I wanted to share with you, that you're not dead in the water from that process. Now, step two is after you do get the report of the physician, whether or not you get it because the court ordered it or not, you have to file that petition, and then the court is going to appoint the guardian ad litem. A guardian ad litem in Illinois is an attorney who's appointed to assist the court. They become the eyes and ears of the court. They interview the proposed ward. They may verify the medical records. They may look at the facilities, the proposed placement. They're going to look at all of the analysis and report back to the court with recommendations about what they feel is an appropriate item or not item. A guardian ad litem is not the guardian of the person and or the estate. It's an assistant to the court in the form of an attorney. And then, after we get through that process, even if the guardian ad litem comes back and tells the court, I believe that the proposed individual needs a guardianship, the ward needs a guardian, the ward still has their rights. And this is where I think it's also critical that you all have a good understanding. They have a right to be present at the court hearing. Did you know they have a right to have a jury of 6 persons? Very unknown right, because I have never done a jury trial, but they have an absolute right. They have the right to be represented by their own attorney. So not just the guardian ad litem, who is the eyes and ears of the court, but the individual proposed ward has the right to be represented by a lawyer and to be paid out of the estate. And by the way, our state funding, there is some options for the court to pay the attorney out of state funds because they have an absolute right to an attorney. They also have the right to present evidence to the court. They have the ability to confront and cross-examine witnesses. And very interestingly, let's say that their local doctor says, I'm going to give a report of the physician because I think you need a guardianship at the time. They have the right, the proposed ward, to ask the court to appoint an independent expert to do another evaluation. Let's not forget that, because what happens is sometimes a physician has treated that potential ward all of their lives, is part of that circle, and we all have prejudices and preferences, and they think this way. Remember that the proposed ward has a right to ask for an independent evaluation. And the last thing the ward has the right to do is to ask that it be a closed door session. They have the ability to ask the court to do it behind closed doors, and they have the right, and this is very interesting, to tell the court who they want to be their guardian. The court does not have to follow it. They could say, I created and named who I wanted in my estate plan. Or they could tell the court, I don't like this person, X, Y, or Z. I want Aunt Betsy to be my guardian. They can tell the court, and the court can make that ultimate decision. So it's very important that we know what the rights of the proposed wards are to be able to know that they can exercise that. Now, step 5 is that the court's either going to grant or deny the petition, and the court at that point in time, if there is a jury trial, will follow the preferences of what the jury says. And if a guardian of the estate or person is appointed, then the guardian has to then post a bond with the court. And if they are a guardian of the estate, they have to give annual reports of all the finances. And then if they're guardian of the person, they have to report back periodically about various conditions, which we'll talk about in a minute. But that's really the process. And what's critical in that analysis is for all of you to know what the rights of the ward are, the proposed ward as well. Amy, can you clarify for everybody the difference between a guardian ad litem and an attorney for the ward? Because I do want to make that point.
Yeah, so a GAL or guardian ad litem is actually going to be representing what they think is in the best interest of the ward, whereas an attorney appointed for the ward is actually going to take directions from the ward or potential ward. So if I have a GAL that's advocating, yes, a guardianship is appropriate, and the potential ward does not want the guardianship, their attorney would actually advocate for no guardianship. So it is a different role, although they're both appointed by the court, they have very different roles.
That's correct. And so now I want to go back and talk a little more about that substituted judgment. Remember, I told you I would get back to that. So let's say that now the court's gone through and the court has made the decision that in fact we are going to have a guardian of the person appointed. That concept of substituted judgment is where I think a lot of you have a lot of your questions. And what I want to do is make sure that you understand exactly what the probate court says and what the probate act says. It says that the ward, or the guardian with respect to the ward, shall make provision for their support, their care, their comfort, their health, their education and maintenance, and professional services as appropriate. And the role of the guardian is to assist the ward in the development of maximum self-reliance and independence. That we miss. Because there's still, that is the goal, and I know that's the goal of Cornerstone, is to make people maximize their potential. And while the powers are very open and broad, on the other hand, it is this substituted judgment that has to occur. And what that means is you have to determine what the ward would have done in a given situation if able to do so. And it's superior. This is important. The substituted judgment is superior to what the guardian believes is in the best interest of the ward. That is to say, not the will of myself as guardian, but the will of the ward. That's a hard standard. And so what they have to factor in, and what can be argued in court by another family member or the ward himself or herself, is that the guardian did not consider their religious, their moral, their philosophical or life beliefs, and their wishes as though they were competent in terms of what's going on. And only, and expressly considered only, if you can't determine what that is, can you then make decisions on best interest standards. So you have to weigh the decision as guardian, and you have to look at the nature of the proposed action. You have to look at the benefit and the necessity of the action, the possible risks and consequences of the action, and you have to then use substituted judgment for that provision. There are also some things that the guardian cannot do that I think all of you need to know as well. Number 1, they may not place the ward in a resident facility except by court order. They cannot place without a court order. Some people think they can, and they try to do it all the time. I'm sure you know that. Number 2, they don't have the ability to admit the ward to a mental health facility for voluntary treatment. Now, we all know that all of us could go in an involuntary statement and end up in mental health court. If you know my view of life, we're all one step from the edge of that happening, because that's just life. That's the nature of our human existence. But at the same time, The guardian does not have the ability to do that. They do have the ability, however, to file a motion with the court asking the court to do it if the court finds it necessary and it wouldn't violate the ward's mental health rights. Then the court can order additional treatments. Third thing is, the guardians do not have the authority, this is critical as well, to move the disabled adult from his or her home or to separate them from family members and friends unless it is necessary to do substantial benefit, to prevent substantial harm, and it has to be of substantial benefit to the disabled adult or the adult's estate. So you have to investigate the alternative living arrangements and you have to ensure it meets the needs of the ward. There's not this automatic authority that everybody thinks that they have. Now, can they consent to treatment? The answer is yes. For medical treatment, as a general rule of thumb, they can, and they have the ability to access the records of the ward himself or herself. We've already talked about dissolution of marriage. I also want to tell you that if you're guardian of the person, you still have a duty to advise the ward's family of any type of death or arrangement, for example, hospice, something of that nature. The statute is very specific. And lastly, you still have to represent them in any kind of legal proceedings. So that's really the guardian of the person, and that's the essence of that. That gets compared with guardianship of the estate. Amy, you want to talk about some of those requirements for us?
The guardianship of the estate, like we talked about, is really primarily over the financial piece of everything. I've had several judges tell me that if we're just going to have Social Security disability coming in, we're not going to appoint a guardian of the estate. This is more if we have more assets that we actually need to manage. Again, it depends on your judge and on your county, because I think more judges in DuPage County, for example, like guardians of the estate, even if we only have Social Security disability coming in, so that they can monitor that and that there's no fraud as well. So again, it depends on your judge and where you're at, and that's by actually talking to a lawyer, they can give you a little bit of information about how your judge feels about that. But basically, they are charged with making the financial decisions. They are charged with the fiduciary duty, I think Gwen touched on as well, that they actually are accountable to the court. They must report to the court either on a yearly basis. After the first year, sometimes the court will go to a 3-year or a 5-year basis, but they must report to the court about that financial status and every expenditure they've made from the ward's assets and why that expense was made. And the court then actually has an opportunity to approve a future plan or disapprove that future plan if they think that those expenses are no longer how the assets should be spent. It's honestly a little bit tighter than the guardian of the person, because I think guardian of the person covers a lot more topics than the guardian of the estate. It's a lot tighter. We're really just looking at funds. Honestly, for most of our guardianship cases, there's not a ton of assets because we actually spent those down to make sure we could get Social Security disability. So we're not really looking at a lot of money going in and out of that ward's estate unless we're looking at an elderly guardianship.
And then let's talk about that in the event of how we create the special needs trust to be able to allow the disabled adult to then continue to get services.
So we do a lot of special needs trusts, especially in connection with divorce cases where mom and dad are no longer married and we have a disabled child who's getting ready to turn age 18. That special needs trust is going to become extremely important to be able to slide child support into. If the child or the potential ward turns 18, and as we talked about, child support doesn't actually terminate until they graduate high school. And by the way, judges are determining that the graduation of high school is actually at the 21 age mark when we're from the extended program. So we'll be looking at an age 19 termination of child support, but if that potential ward is receiving child support at age 18, it's income to that person, no longer to mom or to dad. It's income to the potential ward, which means that they could then get kicked out of Social Security disability depending on how much that child support award is. So Illinois actually did make a good step for once and made 513.5 is what we reference it as because that's our statute number. That's for the easy phrases, it's for child support post age 18 or post age 19. Those funds can then actually be split into a special needs trust specifically pursuant to statute to make sure that it's not income to that potential ward. You can also use that special needs trust for other assets, obviously. If you're going to have a grandpa or grandma pass away, and you have that potential ward, you'll want to put that inheritance in the special needs trust as well, so you don't lose your Social Security disability. So not just for divorcing parents is a special needs trust important, but especially if parents are not together, that special needs trust needs to be in place immediately.
And in addition to that, in estate planning, when you have perhaps a child who is a disabled adult, in your estate planning, you might want to put that money into a separate trust, because then it's not within the scope of the guardian of the estate. It's really in the scope of whoever's appointed as the trustee of that given trust.
So one thing actually, so if mom and dad are together, let's say, and grandma is going to be giving your disabled child $100,000, we'll make up a number. If that $100,000 actually touches their hands at all, even if it goes into a special needs trust later, it can go actually for a Social Security look back. So you're going to want to have grandma put right in her will, it's going straight to the trust, here's the trust number, it's never going to touch their hands whatsoever.
And so that's an interesting. And do you have the document about transfers of trust there?
Transfers of trust.
Yes, thank you.
Of
And the last thing I want to cover in terms of some of your questions, which we are going to go through in more detail, is removal, transfers, and termination of guardians in Illinois. Because I think that perhaps some of you see some instances where somebody had a guardianship and then maybe they're getting to the point that they don't need a plenary guardianship, or alternatively, maybe they don't need a guardianship at all. And how do you advise somebody with regard to that? First of all is, just because you have a specific guardian of an adult doesn't mean that that person continues in that state forever. There are 3 processes available: removal, transfer, or termination of guardians. And it's important to know that. Removal of a guardianship is governed by statute, and that's really where the guardian has acted inappropriately. In that case, you have a representative who's engaged in false pretenses. Perhaps that representative has now been adjudicated to be a disabled person themselves. They've now been potentially, subsequent to the appointment of the guardianship, convicted of a felony. They either waste or mismanage the estate of the ward. They conduct themselves in a manner to endanger the ward, or they endanger the surety or the bond, and they fail to give an appropriate bond. These are some additional reasons. If you fail to file the inventory, right?
Correct.
You can lose your guardianship. If you become incapable or unsuitable, you could lose it. Or there's a catch-all provision. Anything else that the court deems is appropriate. So, the law allows any person to be removed or to seek a removal of a guardian. This is something that people don't recognize. Is if a family member isn't the guardian, doesn't mean that they don't have anything that they can do. They can file a motion with the court to have that guardian removed. If the ward himself or herself says, hey, guess what? I don't want that person to be my guardian anymore, they can then ask for it to occur as well. In that instance, once the court is aware of it, the court's going to issue a citation to the guardian saying you need to give certain discovery, meaning you have to give documentation of what you did with money or what programs you enrolled the ward in, or alternatively, after discovery is completed, the burden of proof can transfer to the guardian to explain what they did with the money. And then at that point in time, the court has the ability to remove them if the court finds that any of those items occurred. That's step 1, is you can have removal. Step 2 is that there can be a transfer of guardianship. And that's when a guardian is removed, either voluntarily or, in the prior one it's involuntary. But if they want to voluntarily remove themselves and say, I can't do this anymore, maybe my life situation, I got remarried, I've decided to have more kids, whatever life brought, you can then transfer the guardianship to somebody else appointed by the court. But the third mechanism here is termination of guardians, which I think all of you need to know about. Anybody, including the ward, can file a petition. But guess what? It doesn't have to be a formal petition like in the form that we gave you. Do you know that it can be a request communicated to a judge or a clerk of the court by any means? It can be through, your request can be through an informal letter, a telephone call, or a visit to the courthouse. And at that point in time, if the court gets a request, they must appoint a guardian ad litem. Remember, the guardian ad litem is the eyes and ears of the court to conduct an investigation about what has to occur. They can also move to terminate a guardianship without a report of a physician. That's key. Just because you had a report of a physician before, you don't need to have it to investigate it again. The ward in that instance has the right to have counsel. They have a right to again ask for a jury of 6 persons to present evidence and confront and cross-examine their witnesses. and their attorney's fees can be paid out of the estate. And the court in that instance, and this is what's critical because I think this is what affects all of you, the court can do the following. They can simply dismiss the petition and say the guardianship still is appropriate, we're going to keep it where it is. They can terminate the guardianship altogether. The court could remove or revoke the office of somebody who's been appointed. Fourth, they could modify the duties. Remember the limited guardian? So it could become limited at that point in time. They also can require the guardian to get specific training. And you know, there is specific training available to guardians now. And then there's a catch-all. Court can do whatever they deem to be appropriate or necessary. So I would assume that if you have not been called during the course of your career to testify about the termination or the modification of guardianship, that's something where all of you could be called into court to be a witness to say, what is this ward, in your opinion, your professional opinion, capable of doing? What is it that you're seeing? Are you seeing that their best interests are being followed through? Are we doing substituted judgment, or are we doing best interest? You know, are we not following the wishes of the ward? Those types of instances are where all of you can somewhat become activated in the purpose or helping the ward terminate or modify their guardianship. Because as we all know, but for the grace of God go I might be in this situation today, but 2 months from now I might not be in this situation, or my situation might progress differently. And so understanding that termination, and what's critical for everyone to know is that you can do it by a phone call, a letter. It doesn't have to be that formalized process. And I think that knowing that is another way that gives you the avenue to help people who are in your facility or that you care for. So now we're going to get to the questions that you ask. So Amy, if you can read the question and provide an answer.
The first question that was posed is it possible to reverse guardianship, and how? I think one actually just went through that process, but it absolutely is possible to reverse the guardianship. And again, I think knowing the judge, many judges will go to then a limited guardianship of some kind if a ward is actually coming in a little bit differently, but it's essentially, just like the question implies, it's the reverse process of appointing the guardian.
Correct.
It's very similar. The second question is, what is the legal position of supported decision-making in Illinois? That's exactly what we were talking about when we talked about substituted judgment of the guardians. We're not looking at a best interest standard. The law uses best interest in a lot of other areas, so you'll hear actually people go right back to best interest, but in guardianship, that's not the standard. The standard is what the ward would want, unless we can't determine what the ward wants, and then we go back to a best interest standard.
The third question?
Does guardianship give the guardian the final say in all elements of the treatment plan? If there's a plenary guardianship, it does in many aspects, although one of the things that I thought about as we were talking about the age 18 versus age 19, what about the mental health age of consent?
Right, the mental health age of consent, all of you know that. What is the age to release records? It's 14. It's interesting, isn't it? So that's
much lower.
It's much lower, yeah.
Yeah, so as we were working through the limits on the plenary guardianship, mental health age of consent is 14. So if you have an individual that's 18 and we have a guardianship, that may not actually trump the mental health, because
Right.
Mental Health Act is a completely separate act. And again, Illinois is not always great about putting our laws together from the different areas. So the Mental Health Act has other exemptions than the guardianship does.
And I want to go one step further. For release of records, it's age 12.
Right.
So it's even younger. Very interesting. Yeah. Yeah.
So there will be some limits, but really what the issue would be is if you're coming up against a problem and you're talking to the guardian, their fallback is always ask the court's permission. Ask the court's permission. You can always ask for the court's permission to do something, and then they can guide you on how that guardianship should, or how the guardian should act.
But if the ward is not happy with what the guardian is doing,
They can
let's
do the
not
same.
forget that the ward also has the ability
Right.
to go back to court as well.
Correct. So it'd be either one. If the guardian is questioning or if the ward is questioning, either one of them can then go back and ask the court how the court would feel and what the court thinks that they should do.
The fifth question?
What are the rights of us as an agency? Can we refuse a guardian's request if we feel it is not in the best interest of the person? No. And again, it's actually not a best interest standard. So as an agency, although you may think it's not in the best interest, that guardian may be acting as what they feel that the ward would want, and so they're actually still fulfilling their duties.
Or if they can't determine, then it can be best interest.
Right.
But what I do want to say is that if there is across the board policy of the agency, that's different. So if all individuals, because let's all talk about that. We have to treat everybody equally who comes in the facility. So if that's going to be the standard of the agency, I think you can then say this is an agency standard. But on an individual case-by-case basis, I would not do that. But then if there's a real conflict, I think that then pointing out that there are certain procedures available in the court, that might be the way to
That was the
give
next
some
issue.
insight,
Is
right.
absolutely, again, if you are dealing with the ward and the ward is questioning what their guardian did, it's again back to court to see what the court would have to say about it.
Okay, question 6.
6, how can we best support a person who is their own guardian who may have a friend, family member that has directed them to make decisions that are not in their best interest? I mean, if the person is their own guardian, they get to make their own decisions. So it's really about supporting them and empowering them that they get to make their own decisions. The court's not going to say anything about it. We at that point don't even have an open case, I would assume, if there's no guardianship in place. So that ward gets to make whatever decision that they want, and just
And in that place, really
empowering them.
not called a ward.
Right,
They're really
right.
just their own guardian, right?
Right.
And so I think you just have to make sure that you're saying, if a family member is in, do you have any letters of office? Because that's really what it is.
Right.
You have to have the letters of office saying, I'm guardian of the person, estate, or both.
And that's actually what we counsel people on. As your child is turning age 18, no one's going to talk to you unless you have a guardianship or powers of attorney in place. So challenging that person who is trying to make decisions is certainly the correct route.
Okay, the next question.
What is the difference between plenary and limited guardianship? That's what we started to go through, and it actually ties into the last question. So I'll go ahead and read the last question with it. Are plenary guardianships the norm? So we actually sat down and talked about that question before we came in, because I don't know that I've ever done a limited guardianship. I've only done plenary guardianships, and then we started talking about the different approaches. But I know, for example, the judge in DuPage County will sit down and actually have a conversation with the potential ward about what decisions they might be able to make before he'll ever make his ruling on what you're going to do with the guardianship, because he does prefer to do limited guardianships. In Cook County, I don't think I've actually ever seen a judge really sit down and have a good conversation with the ward. They may talk to them very briefly, but they're not going to have the same level of conversation that they do in other court systems. It's much more common to do a plenary guardianship. It's also an issue in the legal component. If I'm saying that I can make decisions in this area and this area, how am I actually going to prove that I can't over here? It's a little bit harder, and I think it goes back to the same thing we were talking about with the physician's report as well. They don't know how to write a physician's report saying he can make decisions over here, but not over here. So
Right.
plenary are quite frankly more common, especially at the get-go. When you would see more limited guardianship is as the ward progresses and actually comes into court themselves to challenge the guardianship.
And I think that's important to know, as attorneys, generally we are here to protect our clients, but in this area of the law, we also have duties to the wards themselves to make sure that we're promoting something that's going to be in their best interest. So think about that, like Amy was saying, from a legal perspective. For us to go in and say, well, we think these decisions and not this decision, it puts an attorney in a very awkward place, and I think that that's been part of the evolutionary process. I think that this would be a very good exercise for the Illinois legislature to maybe expand the definitions a little more, because I think that, let's all be frank. We put people in buckets in our society, and we don't make exceptions, and there are exceptions, and there are individuals within that structure, and bad case facts make bad law.
Yeah.
And as a result, although the statute anticipates limited guardians, it's not been the norm in operation, and I'm assuming that's what you all see in your practices that you have.
I actually say that phrase a little bit different. Interesting case facts make bad law. Because the cases that make the headlines of the interesting things, just like the 700,000, are not exactly the norm. But then Springfield gets real nervous and makes new laws about it. And then we're stuck to apply those to cases that don't have those same interesting facts.
Right. All right, so we hope that answers the questions. We're willing to take questions that all of you may have, that we can facilitate some answers.
I'd like to
Yes.
circle back to the supported decision-making
Okay.
issue. There are states, Texas comes to mind, where supported decision-making is actually in the statute as a precondition to guardianship. And the idea being that it's a structured agreement that the individual enters into with supporters. It may be more than one, where the agreement actually stipulates that this individual's going to help me with my financial decisions. This individual's going to help me with my medical decisions. This individual's going to help me with my living decisions or employment decisions or whatever. An agreement that's formalized, notarized, signed, all of that stuff, as an alternative to guardianship. We at Cornerstone are really interested in pursuing a supported decision-making approach with the people we serve, and obviously we serve a number of people who don't have guardians, which I think is kind of fertile ground for the supported decision-making approach.
Absolutely. Then
Then we have people who have guardians where the supported decision-making approach might lead us into conflict with the guardian.
Sure.
I'm wondering about, like, from your perspective, that kind of an approach where the person chooses supporters that can help them with certain aspects of their lives, help them with decision-making certain aspects, formalize that kind of a thing in an agreement. What impact would that have then on potential guardianship or potential change of guardianship?
Again, it based upon my reading of the case law, is that it's a factor that the court could consider, but the court is not bound by it at all.
We
And
don't
so that
have a
becomes
formal
right, So
mechanism.
we don't have that formal mechanism.
Yeah.
We talk about substituted judgment later in the statute under guardian of the person, but we don't have a formal, and I think that from Illinois' perspective, and I'm not saying that I agree with it, but if they haven't created that estate plan or never got around to doing it, we're kind of stuck with it. With the alternative model. But I don't think that that model is an inappropriate model, and I think a lobbyist could certainly make that argument in Illinois, because again, these are older statutes, but it's the time and the cost in the legal system. And I think that that's why we're getting into that the net result is we have limited versus plenary, but we always end up 99% of the time with plenary.
Well, the life of a new law is so lengthy that even when you propose a new idea like that, it's generally going to be several years before it would actually get into play.
Yeah. So we have set up for Equip for Equality to come out and talk to us
Right.
about
Sure.
supported decision-making and an approach like that. And I think our position is that to the extent that it will help us chip away at limits to the person's independence,
Right?
we think supported decision-making is a tool we'd like to pursue
I think it's a great model. Yeah.
and kind of build up our competency as far as that goes, and then see where it leads us.
And I do think it'd be a major factor when you're talking to a judge about whether a plenary or a limited guardianship would be needed, because if that potential board has supports in place to make those decisions, I don't think the judge would say you need a plenary guardian then that's going to oversee everything.
And I'll give you an example of almost the Illinois attitude towards it. First of all is that the bar for the guardianship is not a huge bar.
Yeah.
Secondly, it is one where the compensation for the attorneys being approved by the courts are more limited than general. That's just a fact and reality. And the third thing is recently I went to an entire day seminar, and although I had to leave early, I had all of the materials, and the limited guardianship or substituted judgment section was about this much text in a package of material that was hundreds of pages. So it shows you almost that demeanor there. So unfortunately, that's the state we're in. So I think it's going to take a long time, but I do address and think that's a greater model to go with.
Yeah, Illinois is a custodial state.
Right, that's just where it is, yeah.
And we're kind of a thought leader.
Right,
in
well, that's a
terms
good
of-
place
yeah,
to be, right.
Well, Illinois is a thought leader in terms of institutionalization.
Sure,
Yeah.
right, I
And
get
so-
that, I get that, instead of the
so-
independence. I
Yeah,
understand
so
what
we're
you're saying
kind
now,
of,
yes.
I think we have a heavy load.
Yeah,
there.
you have a heavy burden going forward to get that changed,
Yeah,
absolutely.
but we, it's something the organization has decided we want to learn more about, tackle, push
Sure.
as an alternative.
And I do think that even with the model we have is having the understanding of, the termination process, the modification process gives good guidance, because it's so interesting, because I would love to hear, and I don't have a statistic for you about how many times people really just pick up the phone or write a letter to the court saying it needs to be modified to be limited. I don't think that mechanism has been utilized.
I would agree with that. I feel when you're in the probate court, in the guardianship room, I feel like it's usually quicker cases where you have the ward there, the ward says, yes, I want mom or dad to be my guardian, and then they don't really go and review that for years, if ever, until mom or dad now actually can't make those decisions anymore. So I mean, I agree. I think it's an underutilized area of coming in and saying, hey, actually, we've made really great progress and we don't need a plenary guardian anymore.
So at least there's that tool available.
Sure.
Any other questions or comments? Because we're certainly eager. Yes.
So we have an individual who has a guardian who is not very supportive of any decision he makes, even though he can make many decisions. And so how tough is it to try this process of actually having him term his guardianship?
I think that it's an available process. I think that, it's a standard of overcoming. So I think that when a ward goes in with no support, it's more difficult. But if you wanted to say, I'm going to support and testify and to bring all of that forth about what those tools and mechanisms are, I think it's a real possibility.
I mean, she uses punishment a lot, and so like she sent him a bunch of gifts, and now she wants them all back.
Right.
I mean, it's
just
weird stuff.
weird
you know what I'm
right.
saying? So
I understand.
It's, really, it's infuriating to us because again, it's not appropriate.
Right.
He's not a child; he's a grown man.
Absolutely. And empowering a little bit, having that ability, and I think that all of you do have that. Because remember, it's any person can file the motion to terminate or modify. It's not limited to the ward doing it himself or
We've
herself.
never done that. I've never even thought about doing that, so that's all news to us. So I mean,
Right.
for this young man, it's something maybe we should look into because we have two people right here that are just like, we want to do it.
Right.
I mean, they're very interested in doing it.
Right. It's an alternative, yes. Any other questions or comments? Yes, sir.
When it comes to the substituted judgment, in a case where there is an individual with multiple guardians, how does a court reconcile differences in their opinion on what actually constitutes substituted judgment?
Co-guardians must make co-decisions.
Okay.
Everything has to be by agreement. And that's actually one of the large areas that I do in practice is severing a co-guardianship when the parents were divorced and thought at age 18 a co-guardianship was a good idea, and now it's not. But they have to make joint decisions. It has to be a consensus. If one says no, then it's no. If one says yes, it doesn't really matter. We have to go with the no at that point. The only option is then actually to go in and have one of the co-guardians removed.
And that's a process that we do engage in quite
Yeah.
frequently. So,
So does a court do nothing in a case where two co-guardians don't agree with one another and they just leave whatever it is?
They can file motions, so either co-guardian could file a motion in guardianship court as well and not try to just sever the co-guardianship and challenge the other one. But generally speaking, what happens is then you get in muddy waters and the court says, well, co-guardians, you clearly cannot actually make the decisions together anymore, so we're gonna have to do something in how we're going to move forward.
So
and
it's
again,
separate.
right, but again, I want to say that it's not limited to the co-guardians filing the motion to modify.
Correct.
Any person that's any interest in the ward's life or the ward himself or herself can file that motion as well.
Including the judge. So actually, if as a co-guardian I file a motion to challenge my other co-guardian, once I get before the judge and I say, well, I want this placement and my co-guardian wants this placement, the judge can actually say, I'm actually going to issue a citation for removal of one of you because I find that you guys can't actually be co-guardians anymore.
Yeah. Interesting process. Yes, ma'am.
Thanks. I had a question about the residential part. So if someone is living like in our Scylla home and wants to move to like, not independent living, supported living, not a nursing home, but before that, assisted living, thank you. So would they need court permission, like through the guardians, to even do the assessment for that? Or could they do the assessment and then get permission once it was determined either way?
They can do the assessment, they can't actually do the,
Do the
guardian
actual
can't do the removal or the placement.
Okay, thank you.
Any other questions?
So, I'm sorry, so we have many aging guardians. They're
Okay.
getting older.
Sure.
So, our last resort then, of course, is go to a state guardian a lot of times, because
Right.
if the guardian dies and they haven't made a successor.
Mhm.
So should we encourage our aging guardians to try and have a successor, and if they really don't choose to do that, do you see what I'm saying? Then we're kind of like stuck.
Right, well, you're not necessarily stuck. You could file, any interested person or the ward himself or herself, again, can file that motion. But I do agree that for the aging guardian, remember that there are public facilities, banks that will do the state purposes. We can then have public guardians to do the individuals, correct? And
Correct.
to do that, and those
But
That's
you
on the
can't
rise.
have an institution do the guardian of the person.
Correct.
An institution
Right.
can only be guardian of the state.
Right.
Okay, yeah.
But it is something that needs to be addressed. And, it's kind of like that elephant in the room, right? You're in that, everybody's getting older, nobody really wants, and let's all face it, sometimes it's the fault that we never created that estate plan in the first place. And if you are a parent with a disabled child, in our estate planning process, we encourage in your will and your estate plan to name for your disabled child who you want to be, if the disabled child could never communicate, who you want to be the successor guardian. And people just aren't doing it. They just never get around to it, right? Life happens, and it's best to ignore it. No, it's not best. It's just the reality of what happens. Fair enough. Yes, ma'am.
After one parent passes or is living, then child is appointed
Okay.
and finances. After the person passes away, does it end at that moment, or?
Well, you would have to clean up the items if you had power of attorney to do that. Actually, it does terminate upon death as a general rule of thumb, and then the probate court would take over it. If the estate is subject to probate, or you can named as an executor of the estate in the estate plan itself, or you can have the court appoint you as administrator of the estate to finish and clean that up through the estate process. And remember, you don't have to have a lot of assets. You could do it through a small estate affidavit. So for example, if somebody had a car and something of a limited amount, but the best way to do it is really to create bank accounts, which would then pass upon death, right? Or you have a trust that would then give the successor beneficiary. There are a lot of ways to avoid probate, and that's what we would recommend to anyone. Yes, ma'am.
All right. If a guardian passed away, and then the ward is left her own guardian, explain it.
Okay, so we have a young lady whose guardian passed away, and the family hasn't deemed anyone as guardian.
Okay.
But yet she's a nonverbal client, really can't say what she wants or wishes. So as right now, she has no guardian. So we're trying to determine if she should actually have a guardian, because she can make some decisions. Do you see what I'm saying?
Then a petition should be appointed for a limited guardianship for limited, right?
But then that would still be like an OSG person, because there's no other family available.
It could be, it absolutely could be. The court can appoint it limited for public or an institution for the estate.
Okay.
Yeah, absolutely.
Because it's just a long process. This poor young lady has no one right now.
I think
Understand.
you could almost do it as an emergency.
You could do it
Under
as
the
an emergency.
section as
You know,
well.
and that becomes, you as an agency, are you guys actually filing these motions, or as interested persons? If there's nobody, what is your policy? And I don't want to get into that. I don't know the position of the agency, but that's something that could be addressed to deal with some of those situations. When you find somebody who had a guardianship and no longer has a guardianship, I would think that somebody would want to take some
Well,
action.
unexpected death. We have
Correct.
to do those,
Right,
yeah.
right, absolutely. Any other questions or comments? Well, I have to tell you, you've been a great audience. I feel like, we were coming in and wanting to make sure that the material was relevant and gave you some information. If you can glean one thing, we are also learning about the policy changes that you're attempting to make here. So I think that that's a great goal moving forward. And it's an area of the law that a lot of people don't know about and they don't want to talk about. So we appreciate your time today. Anything else we can do for you? Okay. Very good. So before we leave, Kelly Garver would like to tell you a little bit about our Building Hope program and how you can become involved with us.
Yep. I'm standing because I don't talk as loud as her. So in your folder, we left information for a save the date for January. So Building Hope for the Future is a program, as Gwen mentioned, we have a holistic approach to family law. So within our office, if you come in, there's just walls and walls of brochures and information from different area professionals, which we've met over the years, that when our clients come in, if they're feeling paralyzed or inundated by the whole process that's bringing them into a lawyer's office, we can give them some information to walk out so they can just additional help outside of it. So with that, in 2018, we spun off a program which we call Building Hope for the Future, which we open up to the community, and every month we host a different program on a variety of different topics. So we do have some information about that, but our January program is going to be in the third week of January, and it's going to be hosted at the Cancer Support Center in Mokina. So we're going to open that up. The Cancer Support Center is going to present that program because, unfortunately, many of us, whether it's been ourselves, loved ones, or friends, have all been affected affected by cancer at some point, so just to open up that there's some information out there. So there's information here. I'm also going to hand out our business cards too. If you have any questions, we're happy to always offer a free 15-minute phone call. If you go home, and we're all 3 a.m. thinkers over here, so if you think of something in the middle of the night, just give us a call in the morning. But we also have a YouTube page, Facebook, Instagram, LinkedIn, so we're all over the place. So we're actually today, as part of what we're doing out here, is we're filming the facility so you guys can use it to help raise awareness of Cornerstone and the awesome services that you provide. So we'll have that up on our YouTube, which you could find at Sterk Family Law. And then I know Gwen sat down with Ben Storks a couple months ago and did talk about something, so I encourage you to go follow us on there. We do a lot of informational videos on there, and then follow us Facebook, Sterk Family Law, Instagram, and all that. If you have any questions at any time, just give us a call.